suspect, and he's accused them of enabling widespread voter fraud. Greg Clugston, Washington.
White House correspondent Greg Clugston will be traveling with President Trump to Georgia tonight for that event. Out of Wall Street, a booming session on Friday took the Dow above the 30,000 mark after a 248-point gain. This is SRN News.
Take Faith Talk, AM 570 and 910 with you wherever you go using our mobile app, letstalkfaith.com, Alexa, TuneIn, iHeart, and at radio.com.
Ask an Attorney is sponsored by the law offices of Joe Pippen. Learn more at attypip.com.
Churches where...
Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. Hey, if you have a legal question, you have a toll-free number, 877-943-9673. I'm a host of Ask an Attorney, all about Florida law now. Entering a little bit past, have started a couple of months into my 37th year, longest running continual show, same host, same format in Florida. And I'm glad to be here. It's a Saturday morning early, and the law office is open, and we're here to help as many people as we possibly can. All you have to do is to dial that toll-free number. Your question can be about wills, trust, probate, guardianship, power of attorneys, healthcare surrogates, living wills, can be about family law, real estate law. It can be just about a problem. If you have a question, I'd be more than glad to help you. The toll-free number is 877-943-9673. That's 877-943-9673. Hey, let's go to Jack in Tampa this morning.
Good morning.
Good morning, Jack.
I had the question that I heard on one of your trailers about getting out of a timeshare obligation, and that you had someone that helped you personally do it. I would just like his name if you could give it to me, please.
Jack, I'd be glad to share that with you. Can you send me an email?
Yes.
Or you send me an email and ask me to forward it to the the attorney that helped me with my timeshare.
Okay.
And I will send that to him per your request, and he will give you a call and help you. He got me out of mine very, very quickly, very efficiently, and without too much effort. I was very, very surprised, and I finally found someone that can do that. But thank you so much for calling.
Okay, could I get the email address, please?
Yeah, it's Joe, Joe, at attypip.com. Joe at attypip.com.
Thank you very much.
Thank you.
Okay.
All right, so that was a timeshare experience that I had. I've been looking for someone. I kept hearing stories about people being ripped off, and these timeshare companies that advertise they can get you out. They want a big down payment, and then most of them I would hear never did anything to help the client. And it was very discouraging, and I happened to have 3 timeshares I eventually wanted to get out of, and so I used this attorney as the attorney based on what he could do for me. I knew he could also do for clients. And sure enough, he got me out. Now, all timeshare companies are different. Some are more difficult to get out of than others. But he wrote one letter, and the timeshare company agreed to let me deed them back to them with no cost. No annual cost to me, no exit fee, and I was able to do that. If you'd like information, if you'd like this particular attorney to call you, I will be glad to, if you send me an email with your phone number, I'll be glad to forward that to the attorney with your request and have him give you a call. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. If you have a legal question, you have a toll-free number, 877-943-9673. That's 943-9673, and phone lines are open. I'd be more than glad to help you with a legal question. Your question can be about wills, trust, probate, guardianship, power of attorneys, real estate, family law, traffic law, problems at work, problems with your neighbor. Just have something you want to discuss with someone. I'll be more than glad to discuss it with you. That's what I come in for. You're listening to a live show, and you have a toll-free number, 877-943-9673. That's 877-943-9673. Hey, suppose you're having conversations with family members, and they have always told you that they're going to give you this or that in a will or trust. They want you to have it. They talk about it. It's a continual conversation. And then they die, and there's nothing in writing of what they promised you all those years. What do you do? Well, that's an interesting question, and that does happen occasionally. A lot of times it deals with a personal item. It could be a piece of jewelry. It could be anything. It could be something special. It could be the grand piano. It could be the grandfather clock. It could be a special piece of jewelry. It could be something special handed down from generation to generation to generation, but it's a personal item, and you want it. And it's been discussed. And person dies, and then there's nothing in writing about where it goes. What do you do? Well, the four corners of the will document are going to control what happens to the person's estate. The will has what's called a separate writing or personal list of personal things, non-titled personal things. So if it really means a lot to you, I would ask the personal representative if you could maybe get it appraised and have it as part of your share of if you're entitled to, something else in the estate. Or you could, if worse comes to worse and you really want it, you could buy it from the estate. And that's just two of the talking points or options you might have. There might be some other ones depending on the circumstances. Let's go to Harry in St. Petersburg.
Hello, can you hear me?
Harry, you're loud and clear.
Good, great. I just getting ready to sell a house, and I have just signed a post-occupancy agreement for a month, and I probably should have had a lawyer look at it first, but I wanted to be nice to the buyer and went along with everything they said. One of the things they said in there, they want $4,000 to rent my house back, which I didn't have a problem with, but they want a $10,000 security deposit. And basically the way it's worded is they get to decide, how much and for what reason they can refund my money. They have 5 days after my rental agreement's up, but basically they're in the driver's seat. Is there anything I could do to now? Unfortunately, I've signed this, and is there anything I could do at this point to be able to, protect my legal assets here? Because I was thinking if I had a copy of the inspection report and maybe did another inspection when I'm getting ready to leave the premises, I might be able to limit my exposure.
Okay, so you're going to rent the property that you're going to buy.
No, I'm selling the property. I'm going to rent my own home back for a month.
Okay, and you're going to rent your own home back for a month. Okay. Yeah, well, I guess you have to control it by the inspection reports and have more control over what they can take the money for.
Yeah.
And have it more defined. You're right. You have to have it more defined. They can't just say, well, look, there's a scratch on the wooden floor that was never there, and I'm keeping your $10,000. Going to replace the floor. I mean, it doesn't make sense that they have total discretion to decide on, because the normal standard is reasonable wear and tear. I mean, and what can happen in a month? Very, very, very.
Yeah, there is some wording about things that are up above and beyond wear and tear. So I guess that's that makes sense. But I mean, there's also something in there about mold, and there's other things about damage. That I don't even understand how they're going to decide. What was there before versus what would occur. It's just a lot of money, $10,000. I would.
Well, tell them, on things like mold, tell them it's 30 days. You want to scratch out the mold clause,
Too late. I've already signed.
Oh, you've already signed it? Okay.
Yeah.
Well, you're going to be just in an argument if it comes up about what's reasonable wear and tear, I guess.
Yeah. And so, like I said, is there any way I can, minimize my legal exposure here with the inspection reports?
Well, yeah, you're going to have, there was an inspection done, and who paid for that inspection, the first one?
Yes, they did.
And how long ago was that?
A couple of weeks.
So you're halfway into your month?
No, the month hasn't started yet.
Oh. Well, yeah, get your own inspection report to start with, and have them look at the other one. Sure.
Yeah, those two things I figure is the best I could do at this point. Again, I just wanted to get along and be a nice guy about it, but then after I read this 5-page, post-occupancy thing, I'm like, man, I should have probably had a lawyer look at this.
Yeah, well, I think now, since you've already signed it, when does the rent start?
The first day that we go to closing.
Okay. Just get your own inspection report as your backup.
Okay. That's the best I can do. All right. Thank you, sir.
All right. Thank you. All right. Let's go to Mark in Jacksonville.
Hey, good morning.
Hey, good morning, Mark.
This is a question about child custody. I've been divorced for about 10 years, and we share custody of a now a 15-and-a-half-year-old daughter. And I'm a wonderful, reasonable person, and my ex-wife, of course, is not. But over the last, on and off for about a year, we have defined visitation, every Wednesday and every other weekend. And all of a sudden, not all of a sudden, but over the last year, on and off, but it's been much more regular here lately, that my ex-wife will say, well, she doesn't want to see you. She's got this going on and that going on. And we try to reschedule, or I do anyway, and she's just not into it. And it basically comes down to she doesn't want to, spend time with you. Well, I'm still paying child support. It comes out of my paycheck every month. I don't want to have to run to a lawyer every time, she gets a splinter in her rear end because it's expensive. But I mean, that certainly is not a legal standing because she doesn't want to come see you or spend time with you because she's a 15-year-old girl. We're not going to, we're going to have to make her, I don't know if I want to do that, but I'm just saying, I'm still paying child support, and she's contravening the written lawful order.
How often do you talk to the child yourself?
Not very much. It's controlled by her mother. She's doing this. She doesn't want to talk to you. That kind of thing.
Have you ever had a sit-down conversation with your daughter when you do have her? Yeah. And does she tell you that the mother controls it and she has no say, or can you ask her, do you really want to be with me?
No, she'll say, Dad, I don't want to spend a lot of time with you.
She said,
but I mean that's her mother talking. Her mother's her. She lives with her mother. Her mother's the overriding influence on her. And, she's a 15-and-a-half-year-old girl. She's got lots of stuff going on and friends and that and the other. But still, I have a legal order that says I have visitation. I mean, I don't want to drag her around the house by her hair. But, I'm still paying child support.
Well, I think you'd have to probably pay that whether you had visitation rights or not. I'm thinking. So here's I kind of look past the current issue. The current issue is the mother's controlling the visitation in your mind, but the daughter, when she's with you, would tell you she doesn't want to be with you. So let's suppose you do get aggressive and go to court to enforce or try to enforce the visitation rights. The daughter at 15 most likely is reasonable. Would reasonably tell the judge she doesn't want to visit with you. Yeah. And she might be old enough and convincing enough to the judge that the judge would just change the visitation order. I mean, I'm thinking that could happen, even though and not change your child support.
Yeah, but then how is that? I mean,
I'm just saying, if it goes to court, you're rolling the dice, and that could happen.
Right.
And if the child is convincing, the child is old enough to convince the judge that, she doesn't want to visit with you anymore and doesn't want to spend time with you. I think the child, at some point, might not be 15, but, but that's very close to be the court listening to what the child wants and do what's in the best interest of the child. And if the child herself doesn't want to be with you, I don't think the court's going to force her to be with you. I mean, that's what I'm just kind of analyzing. I know that's not the answer you want to hear, but I think that's probably what would happen.
But again, and I don't really have too much of an issue with paid child support. I mean, I understand, even though my ex-wife is making far more money than I am. But anyway, but I am forced, and I certainly don't want to pay my $1,000 a month in child support. But I have to. But she can say, one of the main tenets of this is having access to my daughter, and all of a sudden, and not necessarily because of my daughter doesn't want to see me, although that's what she says. I mean, she's being controlled by her mother. Well, Mark, we're still requiring you to do what you're supposed to do legally, but we're not requiring your ex-wife and your daughter to do what we required them to do legally. I'm holding the short end of the stick here.
Well, then the only thing you left to do is file a complaint that the court's orders are not being followed and see what happens. But I'm telling you, the daughter's going to testify that she doesn't want to be with you, and the judge could easily change that.
Mm-hmm. And then
you could petition to lower the child support. The judge would decide whether it's okay to lower it or they want to keep it the same and limit, give you less visitation rights or give the visitation rights solely dependent upon the daughter. And then whatever influence you think the mother has over the daughter, that could be a really side issue the judge doesn't pay much attention to because he's going to be listening to the daughter speak.
Now, let me ask you this, if you've heard this. I'm a nurse, and I work in a COVID rehabilitation facility, and I work with active COVID patients, and she is going to bring that up.
Yeah.
I mean, is that a reasonable excuse for the judge to say, oh, well, keep him away, do away with his visitation?
Well, that by itself, the thing is your daughter, no matter what the reason, I mean, she can use that as one of the reasons, but if she doesn't want to be with you, it doesn't matter what the reason is. She doesn't feel comfortable being with you because you work in a virus environment. I mean, the judge will listen to that, and the judge might say, well, let's, I'm going to grant the daughter's old enough to reasonably state her opinion and belief and wants, and I'm going to listen to her because what she wants is in the best interest, and he's not going to pay much attention to that she's influenced by the mother. He's going to pay attention that she doesn't really want to be with you, and he's not going to make her be with you. I mean, that's how it could turn out. So I'm not trying to be negative and give you a bad answer. I wish I could give you a good answer, but I think that's probably what would happen since she's 15. Now, if she was 5 or 6, that would be different. I think the court would be on your side on visitation, and she, of course, is not old enough to make her. She could be influenced more so than a 15-year-old. Hey, Mark, I've got to move on. I've got a family law attorney with the firm. If you want to talk to her, more, I'm sure she'd be glad to talk to you. But I hope I helped you a little bit reason through this. All right, let's go to Joe in Sun City Center.
Good morning.
Good morning.
I have a question. I have a revocable trust and control of it naturally. We want to make an amendment to that. Do I have to go to an attorney every time I want to make an amendment to do that?
Well, let me tell you the most common amendments that I do with trust are who the trustees are or the distribution. A lot of people think you have to change the trust when you put assets into it, or when the assets change, that changes the trust. So I'm assuming you want to either change trustees or the distribution. Is that correct?
No, I want to just take out where the money is going. There's 2 items for the grandchildren, and we want to remove that and have the parents distribute from them. And it's just taking Article like 3 and item 1 and 2 and removing that.
That's a distribution article.
Yes.
So my opinion would be when you want to change the trustees and you want to change the distribution article, it would be best done by an attorney The fees that we charge to amend a trust are like $150. I mean, so it's not usually a big fee, and then you have the peace of mind that it's done correctly rather than trying to do it yourself.
About $150, you said?
That's what I charge to amend a trust.
Yeah. Well, then I'd like to make an appointment to see you.
All right. Well, we do have an office in Sun City Center, so all you have to do is call the office and make an appointment. Or you can send me an email, and I'll have someone call you. I mean, it's either way. The phone number.
Give me my email? Yeah, okay. Give me the phone number.
Yeah, let me give you my email. Just send me an email. Maybe I can give you a call even maybe today and get you on the calendar. So I'm in Sun City Centers on Wednesday. All right, so the email address is Joe, Joe, at attypip.com.
ATTY?
Yep, attorney, abbreviation for attorney, and then the first three letters of my last name, PIP.com.
Can I have a phone number, please?
727-586-3306. And extension...
Joe.
Go to extension 200. The young lady there that answers the phone runs my calendar.
Yeah. It's 787-586-3306, right?
Yes, sir. Extension 200.
Thank you very much.
All right. Thank you. You're listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. The law office is open. And we're about halfway through the show now. But you have a toll-free number to call the show, which is 877-943-9673. That's 877-943-9673. I'd be more than glad to help you if you have a legal question. Hey, you're listening to Ask an Attorney on multiple stations around Florida. We're on about 15 stations around Florida now. We're broadcasting today from Tampa, from the Salem family of stations, which include 570, 910, 860, 930. We also have some FM components to those stations as well. There's a Sun City Center station where we also have a Sun City Center office. We have two offices in Pinellas, two in Polk, two in Pasco. We have offices in Lakewood Ranch down in south of the St. Pete, Tampa area. We have offices in the Villages, Leesburg, and Clermont. We have offices in Jacksonville. Offices from in between there, Daytona and Jacksonville. We have the Sun City Center offices. There are two FM stations there. We have a station in Haines City, Florida, 90.3 FM landmark Voice of Faith station. The 96.3 and the 100.1 FM stations are in the Sun City Center area. Well, it's nationally syndicated for 2 years. Now we're just strictly on Florida stations. But no matter where you are, you can listen to these programs online. Most of the radio stations have Listen Now online sites. You go to their websites and you can find that and listen no matter where you are. Let's go to Ruth in St. Petersburg. Good morning, Ruth.
Good morning. I got a question about escrow. I sold a condo October 30th, and before I sold the condo, it was a sudden sale offer that I obtained, and it was a real good offer. But before I sold the condo, I had a tenant in it, and the tenant was under housing, and the tenant had mental health issues. And the HOA was trying to force us to evict the tenant, and they obtained a lawyer to attempt to evict the tenant. Well, the tenant, because their lawyer speaking with the tenant, and the tenant, well, she left even after she signed the lease and stayed there a month, but she was, because of her mental health issues, she left. Anyway, the after the during the closing, the lawyers that did the sale for the buyers, they said that the HOA said that we owed them, let's say $2,000 for because they was trying to force us to pay their attorney fees in order to evict our tenant. Okay, but in the meantime, they told me that even though everything closed, that in order for one of me or the HOA to get the $2,000 from escrow, we would have to come to a resolution.
Yeah.
And if we don't, then they just hold it, and it'll eventually go into the I guess Florida State.
Yeah. Yes, ma'am. So that was a very long question, but the answer is yes, they have the right to do that, and if it's not resolved, they have the right to turn it over to the court for you to petition the court to release the money.
Well, they didn't say they were going to petition the court to release the money.
No, ma'am. They turn it over to the court, then you have to petition the court to release the money. So if it can't be resolved, and I need to end this because it took a long time. The answer is they have the right to hold it in escrow until it's resolved. If they get to a point where they don't think it's going to be resolved, then they turn the money over to the court and let you deal with the court to resolve it. So then you file a petition yourself to release the money in the escrow to yourself, because and the court will listen to you. The other side will present their argument. The court decides on where the money should be released to. It's out of the hands of the escrow agent. And all of that is legit and done all the time.
Okay, so the court will notify us about it at that point.
Yeah, well, you'll be notified that it's been turned over to the court. Then you have to have your own attorney probably deal with it from there.
Okay, thank you.
All right, let's go to Tim in Tarpon Springs.
Yes, good morning, Attorney Pippen.
Good morning.
I have a landlord question. I'm the landlord on a single-family residence, and my tenant has brought to my attention problems with a neighboring piece of property, the neighboring house, not owned by me, with barking dogs and them putting their garbage pails in what is my driveway. Do I have any responsibility as an owner to resolve that, other than encouraging them to work out the resolution or take that to like code enforcement or something like that? Do I have any responsibility as the landlord?
Well, you're the owner of the property, and your tenant, unless this gets resolved, your tenant's going to say, I can't live here under these circumstances, and maybe have a right to get out of the lease. So I think as a landlord, my advice would be to write the neighbor a letter not to put their trash on your driveway, number one. And number two, you need for them to have more control over their dogs, which are disturbing the peace and quiet enjoyment of your home by the tenants. And whether or not you can do much about the barking dogs or not, that's going to be a big hassle just to deal with that.
Right.
And some of this depends on what the language is in your lease. Which I'm not looking at the lease document, but some of that is controlled by the language in the lease. But I would let the tenant know you're on their side and you've written them a certified letter.
Okay.
To try to correct this matter for them. And you could tell the tenant they have a right as a tenant to complain to the police about the barking dogs. They have a right to complain as a tenant because they have an interest in the property as a tenant about the actions of the neighbor, but you want to help them, you want to be a good landlord, and you'll write them a certified letter outlining position, but you recommend they do also.
Okay. Yes, the tenant's already, I encourage the tenant to ask, take first step, ask the neighbor, and which they complied with the garbage immediately, which is
that makes sense. That's an obvious violation.
Well, I know it's an obvious, kind of like, why did that get to that point in the first place? And then the dogs have been quieter, and I would think that would be kind of a code enforcement thing. So I just didn't know if it's like, is this something I need to be the lead on, or the tenant first, and then if no resolution, then I need to follow up. But you've answered that well. So
okay.
It's my responsibility first.
Yeah,
Right,
just
thank you.
and I'd have your tenant copy you on anything they write, and you copy the tenant on anything you write, and act as a team. That works well usually.
Perfect.
All right, thank you.
Have a
All
good
right.
day.
You're listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. The law office is open. Hey, we have 20 minutes or left or so. And if you have a question, all you have to do is to dial the toll-free number, 877-943-9673. Phone lines are open, 877-943-9673. Also, I'd like to mention, I mentioned the radio stations, or most of them, I hope, that we broadcast. Also, I don't know if I mentioned Jacksonville, WBOB. Well, we also have an office there in the Ponte Vedra area. Also, we're broadcasting live today on WeBeamTV.com. And at the same time we're doing WeBeamTV.com, they are nice enough to stream me live on my Facebook. So you can follow us video if you want on WeBeam TV or on Facebook, or you can, of course, you can listen to us on audio. If you have an iPhone, we have an iPhone app, Ask an Attorney. And they probably have housed, 3 years of shows on an Ask an Attorney app of all the shows. They have a long list of radio shows that you can listen to on your phone, on your iPhone as well. Let's go to Sharon in Jacksonville.
Good morning. I am a substitute teacher working under Kelly, and during orientation... Hello?
Yeah, you have audio on in the background. If you could cut that off, that would be great. But I can hear you. I just hear a lot of stuff going on in your background.
Are you talking to me or my husband?
I'm talking to you. But if your husband's close to the TV, or radio, tell him to cut it off.
All right, thank you. I think he's turned it down. Well, I'm a substitute teacher working.
I can yell at your husband. What's his name?
Anthony.
Anthony, cut it off.
We both call?
All right. All right, Sharon, go ahead.
Yes, I'm a substitute teacher under Kelly Services, and during orientation, I remember the instructor telling us to deduct our break time from the total hours worked. No distinction was made between the teacher or a substitute aide, and for 2 months I was deducting the 30-minute break time from my total work hours, and I should not have been. And I want to know, are they required to reimburse me for those 2 months of break times that I deducted that they never told me about?
Yeah, tell them you've talked to an attorney, because now you have, and send them a certified letter, and you want to be paid for those hours.
Great. Thank you. Is there for the law code things that I need to quote when I write the corporation?
You were kind of garbled on the last thing you said, but just include the hours and the time that the break time that you were not paid for because you were told not to submit it, and just kind of total it up and put a dollar amount on it and send them a certified letter that this is what that you think you're entitled to.
Great. Thank you.
All right. All right, you're listening to Ask an Attorney, all about Florida law. If you have a legal question, phone lines are open. We have about 15 more minutes for you to call in. So, hey, your question can possibly help somebody else listening. That's kind of the purpose of the show, is to give you peace of mind, give you a direction, and hopefully educate some other people who may have similar problems or circumstances. And just try to give as much helpful information as we can, legal information, sometimes just practical, common sense information. A lot of times I give an answer that might not be a legal answer. I always try to clarify what kind of answer I'm giving, just what would I do answer. So if I can help you, hey, give us a call, 877-943-9673, 877-943-9673. And phone lines are open. We're here to help as many people as we can. If you'd like to learn more about the different radio shows I do in various locations and stations, you could go to our website, which is attypipp.com. attypip.com/radio. So you just want to go to the journal website. It's attypip.com. If you want to just go look at what the radio stations I'm involved with, it's attypip.com/radio. If you'd like to make an appointment to see me, yes, I'm still practicing law. Enjoy what I do immensely. I tell you, most of my career in the legal field has not been work at all. It's been just a great pleasure, and I evolved. In my first couple of years of practicing law, I just kind of did everything to get started. I did criminal, I did real estate, I did family law, it was just a wide variety of anything that I could do. I did and wanted to learn about it, and I wrote about it, and then I published articles in the paper, and then I turned the articles into books. It's just been, I've had a good legal career, I think, in the fact that I've done so many other things to go along with my legal career. Books and television and radio shows and everything. I was able to do all of that and combine it into my law practice, which has just made it a lot of fun. All right, let's go to Gladys in Largo.
Well, I have a simple question, and I hope it's a simple answer. You drew up all my legal work, and now I was told that the money I have in my savings and in my checking would have to go through probate. Is that true?
Did I do a living trust for you?
Yes.
Is your account titled Gladys Trustee and the date of the trust?
Yes.
Well, that does not, anything in a living trust does not go through probate. So whoever told you that obviously didn't know what they were talking about, because that's the purpose of a trust. Things that are just in the name of Gladys and you die, and they're not co-owned or not in a trust or doesn't have a beneficiary, those things would go through probate, yes. But if you have them in the name of your trust, there's no probate.
Now, this is all...
Gladys, why don't you do this? Why don't you, whoever told you that...
Yeah, that was the girl at the bank.
All right. Go to the bank and tell her the attorney said that you're absolutely wrong, and the attorney would like to talk to you. And can we call him? Let me know when you're going to the bank, and I'll block off 15 minutes or so for us to straighten out this young lady at the bank.
Oh, well, thank you. I thought that I was covered. What happened, my kids have put most of my money right now into savings until they decide what they want to do. And when I did that, it's not a lot of money, but to us it is. And the girl told us that I would have to either get all my kids' names and Social Security numbers and I don't know what all. And I thought, well, gee, I thought that was all covered.
No, Gladys, is going to be as simple as this. When you pass away, long time from now, your successor trustee that you've named in your trust will take your death certificate and the trust to the bank. If your bank if your bank account's in the name of the trust, the bank then will, at that meeting, your son will need maybe an acceptance of trustee, which is very simple, like one-page document. He'll need a tax number because your trust upon death has a different tax number, just like an estate would. So your son goes into the bank with the acceptance of trustee, the trust document, a death certificate, a new tax number. The bank then makes him the trustee of this account with no probate. And then he takes over. He does that with all of your accounts, no matter financial, checking, savings. He becomes a trustee of your accounts. Then he pays your bills, no probate, does the taxes, no probate, and distributes the money to the rest of your heirs, no probate. So obviously something got tangled up in the communication with the bank. That's
what the girl says. I'm going to have all your kids' Social Security numbers, and I don't know what else. And what is that POD, paid on death? What is that?
Paid on death is just a way you can own an account with a beneficiary. That would not be in the trust. It would be in your name, paid on death to so-and-so. And that's a way to avoid probate, but since you have a trust, the trust is far better because the trust can take care of you while you're incapacitated, maybe while you're living.
Yeah, well, I see. So that POD doesn't have anything to do with me right now.
No, nobody
because
can.
I have all this other stuff.
Yeah, nobody can get to that money till you die. So it's better in the trust.
Right.
It's better in your trust where it can be used for your benefit while you're living.
Yeah, well, I get. Well, how do I know if it's in the trust?
You look at your account, and it will have Gladys, and after your last name, it'll have the word trustee, and then it'll have the date of the trust. All right, Gladys, you promised me this was going to be a short, simple question. So
yeah, I did.
Okay. All right. So let me move on to my next caller. Okay.
Okay.
All right.
I appreciate it.
Thank you. Let's go to Joe in Jacksonville.
Hello?
Hey, Joe.
It was Richard, but that's okay. I was. What I ask you, I have like 3 times here, and when I was young enough, we got it, and now I got a timeshare. They send me the cover the lines cover the around the place feeding. It's $2,000. Now, my wife is 88 years old. She got dementia. I'm 86. And we don't want to do the timeshare no more. So I could just ignore it or what I do.
Well, if you ignore it, it's going to could mess up your credit somewhat.
But I'm 86 years.
Yeah, well, no, some people don't care. So what that would happen is they could follow a lawsuit, though, and try to collect some other assets. Richard, there might be a way you can get out of your timeshare. If you want to email me, our first caller this morning wanted the attorney that I use to help people get out of timeshare contracts. If you want to email me, I'll be glad to forward your email with your phone number to the attorney to have him call you to tell you how you can legally get out of a timeshare contract. All right, so just send me an email to Joe at...
okay.
All right, or just listen to the show. I've got to move to my next caller, but I'll give out my email address here in a second.
Yeah, I'll listen to the show and get your email address.
Okay. All right, let's go to Joe in Jacksonville. Okay, all right, he's not there. All right. So you're listening to Ask an Attorney all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. If you'd like to contact our office, I'll give you my email address and my phone number. And if you would like to contact us by email, like Richard did there, it's Joe, Joe, at attypip.com. That's Joe at attypip.com. If you want to call us, we have a toll-free number, 800-226-3529. That's 800-226-3529. I'll be more than glad to talk to you if you want to make an appointment or... Oh, let me mention, too, I'll give out those information again here in just a second. We did a series of every other week, and we did seven of them over a 14-week period. We did a Zoom seminar, and we're going to continue those back in January, by the way. But we have 7 topics, unlike the radio show where I do a multitude and a wide variety of questions and answers. The Zoom seminars are on one topic. So we did an hour Zoom seminar on estate planning. We did an hour Zoom seminar on living trust. We did an hour one on probate, Medicaid, asset protection, family law, stand your ground, concealed weapon, gun seminar. So we did 7 of those. If you would like to receive the link to one or all of those, I'll be glad to email it to you. And if you have an interest in learning more about that topic, or the topics I just mentioned, you'll have an hour Zoom where you can watch as much of it or as little of it as you want to and spread it out over time. If you'd like that link, just send me an email. And the email address is Joe, at attypip.com. The first one in January is going to be about living wills versus DNR documents. I'm working on having a doctor do a Zoom seminar on that topic, living wills and DNRs. And during that, I will tell you why I would probably never want a DNR document. We'll go over that. Let's go to Bob in Jacksonville.
Good morning, Joe. I just had a quick question about the possibility of getting a protection order from preventing someone from contacting me. It's actually a family member, but I have some real serious concerns about some safety issues in the event they would travel here.
Yeah, have you been threatened? Have you been threatened before?
Numerous times.
And do you have some documentation of that?
Hundreds of emails and text from this person's phone.
Well, if you have a fear for your own safety, you can certainly get a protection order, I think. And I can, if you would probably call a criminal law attorney or maybe a family law attorney to help you get that protection order. And if you don't have one, I could probably come up with a name. I don't have one handy on the show here, but I could come up with a name. My office in Ponte Vedra is with a criminal attorney, and I'm not sure he handles a lot of traffic cases and types of criminal law, and I'm not sure if he would do a protection order, but he certainly would know someone that does. So I could certainly ask him.
Okay, and I can just contact you through your email address?
Yes, that'd be fine.
All right, Joe, I appreciate your time.
All right. Let's go to Adrian in Bradenton.
Hi, Attorney Joe. My question's about product warranties. As you know, this time of year you buy stuff online and everybody's hitting with these warranties. And I dug into it a little bit, and one of the major warranty companies says, we handle, normal wear and tear, but if you dig into the warranty, it says like parts that wear out are not covered. And so I'm confused by this, and how would I know if something's covered before buying some of these warranties or buying a warranty?
Well, what you just said, you might, it's even car warranties, something happens to your car and you take it and get it fixed thinking it's under warranty, and for some reason there's some little clause in there that says it's not. You just have to read the warranty, and then if it's not clear, then you have an argument if you want to fight it. But most of the time, depending on the value of the item, it's not worth the fight. So I
almost sounds like these warranties aren't worth much.
Well, a lot of them
kind
are.
Of what I'm concluding.
Yeah, but most of them are. Yeah. They're very clear on what they do cover, for example, and then they try to put maybe some weasel words to get out of certain things that they don't cover. So you just have to read the warranty.
Very good. Hey,
all right, I'm sorry that doesn't help you any, but it's the best I can do. Hey, I'd like to tell you, just pray for me and my family. My mother passed away on Thursday. And I didn't want to talk about it because I probably couldn't, but I just wanted to mention that. Okay, so you've been listening to Ask an Attorney, all about Florida law. And if you want to contact our office, we have a toll-free number, 800-226-3529. If you'd like to email me, it's Joe at attypip.com. That's Joe at attypip.com. If you'd like to make an appointment, I'd love to see you. There's no charge for the first appointment. If you want to have me review documents for you, be glad to do that. There's no charge to do that. And if anything I can do for you, all you have to do is call that toll-free office number, 1-800-226-3529. And I hope you have a great weekend, and so long. Be back next week, the same time.